Greetings, everyone. How are you doing today? Can you hear me?
Yes.
All right. I see nods. That's always good. I heard a yes. Thank you. Well, it looks like we've got a pretty full house, and I know time is of the essence for everybody. So I'm going to go ahead and just jump right in and get started here. My name is Mark Holmgren. I think I know most of you. I am, of course, one of the partners at Goodman Holmgren, and I thank you all for taking time out of your day to attend our seminar. Today, we're going to be giving you our legislative update and talking about what has gone on so far in the current legislative session. Unless it happened very recently, the legislature has not yet adjourned, so they still have a little bit of business they're conducting. So there could be some things that we haven't talked about, or maybe some things might change, but we do have a couple of bills that have been passed and will be going into law 90 days after the legislature ends. So I am going to jump in and get started going over what those changes are. All right, we have two bills that have been passed and signed. They're House Bills 2131 and 2158. The first one deals with prohibitions on banning artificial grass, and the second one deals with political activity. They were both signed previously, and they will go into effect, like I said, 90 days after the legislature adjourns. So the ban on artificial grass, the ban on prohibitions on artificial grass. Now, how many of you out there, just show of hands or whatever, how many of you have homeowners in your communities that have artificial grass? Is it a lot of people? All right. I see a lot of hands going up and nodding. Now, let me ask you, does anybody, feel free to unmute yourself and speak up. Do any of you have problems with homeowners who have artificial grass? All right, well, I am a little bit surprised that nobody has any problems with that, but not terribly surprised. I've seen it in neighborhoods where I've lived. I have some artificial grass of my own, and it seems like kind of a no-brainer at this point in time. You save so much money on water, and yeah, this stuff's expensive, but it always looks good. And, you know, at the end of life, 10, 20 years down the road, maybe we'll start seeing more problems with this. But for now, boy, it's really low demand from a maintenance standpoint for the homeowners. Anyway, so the prohibition on banning artificial turf is just what it sounds like. The legislature has decreed that planned communities cannot ban artificial turf in lieu of real grass. So it doesn't mean that the homeowner can do whatever he wants with artificial turf. It said the legislature is allowing associations to adopt reasonable rules regarding the installation and appearance of turf if those rules do not prevent installing the turf where you'd be able to put natural grass. You know, the obvious rationale for this is because of the water shortage. It's just not raining enough in the West, and the Colorado River's drying up. And 30 years ago, when I moved to the Phoenix area, we wouldn't have seen this coming because the CAP canal wasn't finished and there wasn't a whole lot of Colorado River water coming into Arizona. But now we're very dependent on it in the valley, and the lack of water in the Colorado River is having a real impact. So if we can save water by using artificial turf, so much the better, the legislature figures. So you can regulate it, like I said, and you can also require homeowners to remove or replace their turf if it's in poor condition. You know, some of the poor quality turfs don't last real long, and they can start to look bad after several years. And the association, you know, can require homeowners to replace it if it looks bad. So your hands aren't really tied here. I mean, you have to accept the plastic grass. You don't have to like it. But most importantly, you can still enforce your CC&Rs and require that homeowners maintain their yards in a neat appearance. Just because it's plastic grass doesn't mean it can look bad. The statute does include an interesting provision that says that the prevailing party in an action against the association based on this statute shall be awarded reasonable attorney's fees and costs as decided by the court. The reason that's kind of a strange thing to put in a statute like this is because it's one-sided. This statute does not say that the association can recover its attorney's fees in an action brought by a homeowner or an action that the association brings. So in other words, we may reasonably infer from what the legislature says here that the association can't get its attorney's fees. Well, there's a lot of good law in Arizona that says if you have a fee shifting provision that goes one way, the court will interpret it to be mutual. Now that typically deals with contractual language. Certainly we all have seen CC&Rs that say if the association sues a homeowner in collections, the association may recover its attorney's fees. The court will absolutely interpret that contractual provision to go both ways. So that if your accounting is wrong, let's say, and the homeowner wins in court in this collection action, he can recover his attorney's fees from the HOA, even though the statute doesn't, or the CC&Rs don't say he can. The court would probably interpret this statute the same way, but there are no guarantees on that. But more importantly, there are other bases to get your attorney's fees in a dispute with the homeowner. We have the statute that says that the court may award attorney's fees in any action based in contract. CC&Rs are a contract. So even though the legislature is saying in this statute only the homeowner can get his attorney's fees, don't let that fool you. Don't think that's worse than it is, because the association still can recover its attorney's fees if there's litigation based on this statute, because the dispute arises from the CC&Rs. Now, the next statute that before we go on, let me ask, does anybody have any questions about the artificial turf bill that passed? Feel free to jump in and unmute yourselves and just throw out any questions.
Yeah, this is Robert. I do have a question.
You go right ahead.
So just for clarification, so an example, my community, we have 104 homes. None of us have grass in our front yards. It's all rock. So now potentially a homeowner could request to put in artificial turf and we can't deny it, even though no homes were built with turf to begin with? Or am I not understanding that correctly?
Yeah, you can deny it. If you have, I would encourage your association to adopt rules and regulations that say no grass. And there you go. The fact that there has never been, that nobody has grass in your neighborhood suggests to me that if somebody applied tomorrow to put real grass in their front yard, the association would probably tell them no. And so it's okay to tell a homeowner who wants to put in plastic grass no, if you would give that same answer to somebody who wants to put in natural grass. So this is a situation where, I think the legislature has tried to carve this out and say, you only have the right to put in artificial turf if you would have the right to put in natural turf in the same area. So if your association doesn't allow grass, you don't have to allow plastic grass.
Okay, gotcha. Thank you.
Yeah, you're welcome. All right, any other questions on the turf before I move on?
Mark, yeah,
Yes.
I have a question. In your experience, have you ever had a lawsuit involving artificial grass? Is this really an issue that's a litigious subject?
No, I have had a dispute about this as a board member in an HOA about 20 years ago, maybe a little longer ago than that even. And the plastic grass was a pretty new thing. And a homeowner put it in without getting permission. The board was livid. We worked out a compromise. We let the guy keep the grass, but remove the lions. The lions are a whole separate thing, but we let him keep the plastic grass. And it was very educational because the plastic grass still looked great like 10 years later. So I have never been involved in any litigation involving plastic turf. I have been involved in a lot of litigation involving ripping out natural grass to put in xeriscaping. So I know that can be hot button issue with some homeowners. And who knows, maybe we can defuse some of those fights in the future if HOAs decide they want to put plastic grass in common areas at some point to save water.
Thanks, Mark.
Yep, you're welcome. All right, I'm going to continue onward here with the other bill. Now, House Bill 2158 protects the homeowner's right to engage in political activity in the association's common areas. We have talked before, and I see a lot of familiar faces in the audience, and I think most of you probably have a pretty good understanding that homeowners associations are not the government. Homeowners do not have a free speech right in their homeowners associations because the Constitution says so. The First Amendment says Congress shall make no laws abridging the right of free speech or assembly or the free press. People forget that it says that the government can't do those things, right? So your free speech right is as opposed to the government. You don't have a free speech right when you're dealing with a private company. So for example, Twitter, can ban you or delete your posts if they don't like what you're saying. And obviously they have done that a lot. A private company is not the government, and you don't have a protected free speech right unless somebody gives you one. And here the Arizona legislature is doing that for homeowners. This bill gives homeowners the right to peacefully assemble and use common elements if the homeowners do it in accordance with the rules. The homeowners are allowed to assemble and discuss matters related to the association on the common areas. And the homeowners are also allowed to invite a political candidate or non-unit owner guest to speak to an assembly of unit owners or members. So now the legislature is giving homeowners free speech rights in their HOAs for both political speech related to the HOA and also political speech unrelated to the HOA, just political speech, period. And then also the legislature tacks on at the end here that the association cannot prohibit or unreasonably restrict the display of association-specific political signs on that member's own property. Well, this raises a couple of questions. Okay, some people may wonder, well, couldn't they do that before? And actually, no, they couldn't do that before because the statutes that already exist that regulate political signs apply to real politics, not HOA politics, president, Senate, House, those types of things. So this protection for political signs that relate to HOA issues is new. And I don't think this has been a big issue in the past because I think, frankly, a lot of people thought it was already protected. But then this last sentence at the end of this slide talks about unreasonably restricting the display of an association-specific political sign. Okay, well, what kind of restrictions are reasonable? What can the association do to limit signage? We'll get to that in a minute. So, all right, the key takeaways. HOA cannot prohibit assembly by members in the common area, okay? So you may make reasonable restrictions. So if you could, for example, I think it would be very reasonable to require homeowners to register and get permission before they hold a political gathering in the common areas. I think the association may put time restrictions on where the homeowners can, or when the homeowners can gather, and where restrictions on where in the community they can gather. And the reason I feel pretty comfortable telling you these time, manner, place type of restrictions are okay is because the government is allowed to impose those same restrictions. In other words, if you want to have a protest out in front of, Senator, what's the guy's name? Mark Kelly's office. If you want to go out there and stand with a sign, you have to get a permit. And the city of Phoenix can tell you, you can only do it during certain hours. You can't block the street, things like that. And the First Amendment applies to the government. So if the city of Phoenix can impose those restrictions on you, then certainly it's reasonable for a homeowners association to do the same thing. So I think your keys are going to be time, manner, and place restrictions on assembly in the common areas for political speech are going to be okay. Now, as we discussed briefly, the bill also expands the members' right to display political signs in his yard. So these HOA specific political signs, they're allowed to be posted or placed in the yard between the date the association provides written or absentee ballots to the homeowners until 3 days after the election or amendment vote or whatever. So the homeowners have 3 days after the election to take out their signs before you can start giving them violation notices for it. Let's see. Okay, here's the restriction on signage for the association. You may restrict the total dimension of all the signs in the owner's property to not more than 9 square feet, which, if memory serves, that's a more restrictive limit than what's in the general political sign statute limiting signage. So that's pretty easy. You get 9 square feet. So that's 1 3-foot by 3-foot sign, or 9 1-foot by 1-foot signs, or any combination in between there. So it's not a whole lot of signage. Somebody can't plaster their house with these. I guess 9 1 square foot signs would be an eyesore, but it's protected by the statute. So there are 2 bills that are still pending. Let me go back. Let me ask, does anybody have any questions about the political activity statutes that were adopted?
I did, Mark. I put one in the comments.
Oh, okay. Let me look there. Let's see. The bill will go into effect. His question is, does HB 2158 go into effect in July? And if an HOA has a request to use a common element for such purpose prior to that, will it be at the board's discretion to allow it? I would say it will not go in effect in July. They go in effect 90 days after the legislative session ends. And at this point, it's going to be August before these statutes go into effect. So yes, it's in the board's discretion to allow it. I would recommend taking a look at your CC&Rs to see if they allow you to deny a request to use the common areas for that. The homeowners have a right to use common areas. So if you have 5 homeowners who want to get together and sit at the picnic table at the Ramada and talk about an HOA political event, I think they probably can do that under the language in your CC&Rs in most circumstances, but you'd have to take a look at the CC&Rs to be sure. So I think, yes, the association does have discretion to not allow that, but I think that the association probably should allow that depending on what the CC&Rs actually say.
Thank you.
Yes, you're welcome. And I have another question here from Sandy Davis asking, does this include primaries? Yeah, actually, the new statutes will apply to primary elections. And so if homeowners want to have primary candidates come out and gather around the picnic table at the Ramada and talk about political issues, yep, the homeowners have the right to host those kinds of events in the association's common areas, subject to your reasonable time, manner, place restrictions that the association might want to put on those events.
Are we allowed to restrict, like, what can we do if the political language during one of these sessions gets out of hand or violent or, just offensive in general?
Excellent question. Now, first of all, let me preface this and qualify everything I'm saying today by saying I'm not giving anybody legal advice. This is simply educational and advisory in nature. And if you have questions about any specific scenario, we should talk more formally on the attorney-client relationship, and I can give you real legal advice and guidance then. But as a general matter, if you have a fight breakout or ugly political speech, you can call the police. If there's a breach of the peace, if somebody is committing disorderly conduct or something like that, yeah, absolutely, you can call the police and let them handle it. What you can't do is discriminate against speech based on, or not what you can't do, what you don't want to do. You don't want to discriminate against speech based on the viewpoint. And, we're on uncertain ground here because this is HOA speech in Arizona, subject to Arizona law. But if you step back and look at constitutional law as it applies to governmental entities, I'm sure the most of us with gray hair are familiar with the Illinois Nazis that were memorialized in that movie, The Blues Brothers, back in the day. And, they won their case. The Illinois Nazi Party wanted to have a march, and they were told by the local municipality that they weren't allowed to do it. And ultimately they sued and they won. And that's one nuance that makes America different from a lot of the countries in Europe, is that in America, you can't discriminate against speech based on viewpoint. The Nazis have their right to march. The communists have their right to march. In Europe, they can ban certain types of speech in most of the European countries, but in America, you can't. And that's, I think, why we've had such a struggle over the last few years about how we deal with things like misinformation and disinformation and these related issues that you see. And that's, I think, a big part of Twitter's problem is they're struggling with what to regulate and what not to. So you run the risk of inadvertently discriminating based on viewpoint if you take action against a protest or political gathering absent some kind of improper conduct. I mean, if they violate the time, manner, place restrictions, it's valid to take enforcement action. If there's violence, absolutely call the police. But if the Arizona legislature is going to throw us in this sort of free speech arena, now we have to be cognizant about, okay, what does that mean? And my thoughts, just based on my 25 years of doing this, tell me that the Arizona court system is going to analyze disputes under this statute in a pretty similar way that they would analyze a dispute based on free speech under constitutional law. So I can't tell you what's going to happen, but based on my experience, I think it's likely that we're going to have to start playing by the constitutional law rules when it comes to these issues of assembly and speech and politics. Does anybody have any other questions about this? Because I'm happy to keep talking.
Okay, so I know you can't really answer this, but I understand that the HOA wouldn't be able to discriminate against people. But what if the language coming from the people holding the meeting is discriminatory? And thank you.
Yeah, I mean, that's another excellent question. And let's see if we have two examples I can give of that. I mean, I guess the Illinois Nazi case gives you an example of discriminatory speech, hate speech, coming from a group of people at a political protest. And the court system decided that was protected. But what you have to balance against that is this idea of creating a hostile housing environment. And there is law, federal law, from the Department of Housing and Urban Development that says that a planned community or a condominium can be held responsible for the actions of homeowners discriminating against other homeowners. So there's an expectation by the federal government that if you have, for example, a homeowner who's harassing a neighbor based on their race, there's an expectation by the federal government that the association is going to go to bat for that homeowner who's being picked on and harassed and take enforcement action against the homeowner who's doing the bullying. And it may seem pretty extreme that we have this ultimate neighbor to neighbor dispute where it's just an exchange of ugly words between two homeowners. And as of several years ago, the federal government decided that the association now has a duty to interject itself on this, lest it allow the creation of a hostile housing environment. So I think the facts in the hostile housing environment arena are, you have to have pretty egregious facts, I think, to give rise to that kind of a claim. But at the same time, you have now homeowners with the right to engage in their political speech. So it's going to be a balancing act for HOAs. And there's no certain way to know how the court system is going to interpret and harmonize these two arguably conflicting legal duties that the association has.
Hey, Mark,
Yeah.
as a former government guy myself, I understand the case of the Illinois Nazis and you're using that and it's a right to demonstrate whatever they want to do. But that was mostly in relation to doing it on public property. When you're talking about the association inviting people in for political demonstration or rally or whatever, that's happening on private property. And in the event that tends to say, as some people are saying here, get out of control, does not the association then say, because it's private property, it's not a public area, and it's for the membership of that community, does not the association have the explicit right to just shut it down and push everybody out?
Well, the association does have that right, but the problem is you could face liability for it because this new bill gives homeowners the right to invite a political candidate or other non-unit owner guest to speak at an assembly of unit owners or members. So if somebody does invite an outside guest and the association allows them to use the common areas, as you're probably required to do under this statute, and it turns ugly, you can throw the controversial, hateful political figure off your property, but you might be subject to liability for violating the homeowner's right to invite somebody to speak at an assembly. And, in the absence of this statute, the sort of corporate free speech world, if you think about employment law and what you can put on your cubicle and things like that, you would have this idea of creating a free speech zone. If Target has 100 employees in an office in cubicles and it lets them put up political statements, then there's a good legal argument to make that Target can't allow some political statements, but not others because they've created this free speech zone.
Yeah.
And schools are another thing. If the school wants to, if a grade school will allow the Boy Scouts of America to rent out the cafeteria for meetings after school, well, then they're going to have to let other groups use it as well. It becomes sort of an all or none thing. So either allow political speech or you don't allow political speech. And what the legislature has done here is taken away the association's right to not allow political speech.
Yeah, I've read through this, and I've looked at it, and this just spells out another one of those Arizona famous laws of we didn't think it through at the time of passing. Because I have a feeling this is going to create a lot of problems. Because depending on what this is and who is speaking and what's being said, I can see where associations are going to have conflicts because somebody's going to find something that's offensive. And, you could even have your members suing the association for allowing offensive activity.
Yeah, that's
I
conceivable.
mean, they just kicked the door open and didn't care where the animals ran and said, oh, well, everybody has a right to be free. And,
yeah.
I have a feeling this one's going to come back around because this is going to cause more problems.
Mark, I got a question going off of that gentleman, because you're basically saying that as a member, I get to invite my friends, because I'm a member I can use the common area to have, a pro-choice rally in the thing, but I can invite other people because I live in the community. Are you saying that, and I can open up to all the members, say, hey, if you guys want to come, but I'm also inviting other guests. I'm inviting in my friends who may be part of that as well. They believe in the same thing I believe in, whatever. And I'm bringing in, I'm having the speaker, but I'm also inviting other guests to come in. So you're saying I can do all that? Because I I see problems with, because the religious groups are going to now be able to say, we can come in and, you know, because I was invited by a homeowner to speak, we're going to bring the whole entire congregation over.
That's not what the statute says, actually. Mercifully, these are rights that are limited to unit owners and members.
So
Yeah,
it's
so
only for the, oh, you can only invite the unit owners.
yeah, you can invite outside guests to speak
Okay.
at an assembly of unit owners or members.
Okay,
But you're right. I mean, for example, my wife and I both own the house. We both live in a planned community, and I could invite, you know, a Republican candidate for senator, and then she could invite the Democrat candidate for senator, both to speak at the common area, and invite all the neighbors to come witness it. And
okay,
under this statute, I think the association would want to allow that, subject to time, manner, place restrictions.
okay. Just want to make sure, because I thought I heard it differently. My bad.
Okay.
Okay.
Well, thank you for giving me the opportunity to clarify myself. Now, one
I have
thing that,
another question.
oh, go ahead.
I'm moving, so I can't see. Thank you. So can we do rules of conduct in a way that doesn't violate their speech? Like limit, time limit for each homeowner to speak, or, you know, basically the same as it already is as far as, you know, a reasonable amount of time, and who defines that?
Yeah, I think the board would have the right to limit the use of the common areas based on time. So you could say, yeah, you can do it for half an hour on Saturday afternoon at 2 o'clock, or, you know, something else that's reasonable, maybe 2 hours. I think trying to limit each individual speaking time might be a little bit of a reach, but we have no guidance. We have no, you know, there's no case law on this for sure. So all you can do is do the best you can and be reasonable and treat the members fairly, which of course is your obligation for all HOA issues. And then one thing that somebody started alluding to, or did allude to before I gave the answer. Anyway, the question started to come out about, you know, the hateful type of speech and bad speech. Now, one of the other things that we have to deal with are the profane political signs. The profanity issue came up. So, you know, for example, right now we have, you know, the F Biden, F Trump signs. And there's a really good question, I think, as to whether or not those are actually allowed. I've heard some HOA lawyers say that, yeah, you'd have to allow those political signs during the relevant time period of the pre-existing statute. I am of the mindset that F Trump and F Biden are not candidates running for political office. So if you want to have a, you know, vote for Biden or vote for Trump sign, I think those are protected. I don't think the profane ones merit protection under the existing statute, just to get that issue out there. And I think you might consider applying those types of dynamics to the HOA political speech as well. Now, I got a question in the chat here. If a sub-association member hosts an event, members of the master association, would they be allowed to attend? And I think that if you have a sub-association member hosting an event at the sub-association using the sub-association's common elements, then no, I don't think master homeowners from some other sub would be allowed to attend. If you're doing it if you're a sub-association homeowner using the master common area, then yeah, I think then you're really doing it as a member of the master association, and everybody from the master association would be able to attend. But again, you know, this is just advisory. We'd have to look at everybody's CC&Rs and give you real legal advice about something like this because of all the nuances that go into it. Oh, and I have to run through these two statutes that are pending. There are two bills still hanging out there. House Bill 2275. We're running over on time, so I'm going to go through this quickly. House Bill 2275 regulates termination of a condominium. And it's currently in the Senate, and House Bill 2010 protects first responders flags. The condominium termination bill would require 100% approval to terminate a condominium. It's currently 80% unless the CC&Rs require more. So this is potentially huge because it would allow one homeowner to hold out and demand a huge payment in order to allow termination of the condominium. And usually it's a developer who wants to terminate the condominium. So really, this only favors people who, want to be obstinate and try to get a huge payout. I'm surprised the legislature is considering this. The other statute, now we all know that we already have a statute in Arizona that allows homeowners to fly the American flag, state flag, and several others. This adds to it, and that you can fly first responder flags. The association cannot prohibit those. So for, a police flag, fire department, emergency medical, these types of flags would be protected under this statute. I think it's probably likely that this is going to pass if they're not too busy with the other things. All right, any questions from anyone about any of these other issues? Okay, well, I appreciate you all taking time out of your day to attend this. Sorry we went over on time. If you have any questions or you'd like to discuss this, feel free to shoot me an email. It's mark@goodlaw.legal, and I would be happy to discuss it with you. And also, I hope everybody has a really nice, fun, happy, and safe Memorial Day weekend. So thank you very much. Enjoy the rest of your day, everybody.